Welcome to our latest episode of Called to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and this evening, or for her this morning, I'm joined by Associate Professor Imogen Saunders, Director of the Centre for International and Public Law at the Australian National University College of Law. Try getting that on one business card. And author of the groundbreaking General Principles as a Source of International Law, of which I am the proud owner of a signed copy purchased at the actual book launch. Now, in academic terms, that's like having the signed album and T-shirt from your favourite band's breakthrough tour. Imogen, good morning to you in Geneva. First question, what's your drink?
Well, good morning / good evening to you, Douglas. I'm so delighted to be joining you. My drink is a coffee, as it is 9:45 in the morning here. And while the wine is lovely in Geneva, I thought perhaps it was a little early to start imbibing, given I have a day of work ahead of me.
Yes, well, certainly when you're on a major research project tour, that does seem a sensible choice.
And Doug, what are you drinking tonight?
Well, it's slightly shy of the cocktail hour here in Canberra, so I'm having what I think of as a virgin gin and tonic, which is a tall tonic water with a dash of lime. And we'll see. By the close of our conversation, I might be on something stronger, but that will just depend on how the evening unravels. But anyway, as everyone probably expects by now, I like to begin these shows with a little bit of background on our friendships and career paths. So I believe we likely first met in 2020 when I judged a practice mock court round for your Jessup Moot team. We then discovered that we lived nearby and had kids in the same primary school. So would you like to tell your version of how we became friends?
Yeah. Well, not to sound stalkerish, but we actually had met before 2020. I don't remember exactly when it was, but I know it was at a Law of the Sea event hosted at the College of Law. You have done and had done a lot of work with Professor Donald Rothwell, who was my PhD supervisor. And it was something that he'd organised. And I was struck at the time by your impeccable dress sense. And so then some years later, I was dropping my kids off at our local school and I saw this figure in the distance, very nattily dressed. And I thought, that looks like Douglas Guilfoyle, but he doesn't live in Canberra. So I sort of brushed it from my mind. And then I saw you again and I thought, really, what are the chances that there are two people in this world who are dropping off their primary school age child in a bow tie and pocket square? So I deduced that, in fact, you had moved to Canberra, which is when I reached out to you and said, would you like to come and judge my Jessup team? Which you very kindly did. And then at some point after that followed a now infamous night in the chronicles of our friendship, where I was cooking for Christmas and I had made far too many blinnies. It was a recipe using yeast, and Christmas in Australia is at a hot time of year. And as I was cooking the blinnies, the remaining dough in the bowl just kept growing and growing. It was this sort of never-ending magic pudding of a blinny dough situation. And by the time I finished cooking, I had something about 300 blinnies, which was far in excess of needs. And so I put a plea out on Twitter, will someone come and help us eat all these blinnies? Which thankfully you did. And you and your lovely partner came around to help us eat the blinnies. And we've been friends ever since.
Yes. Well, I think the crucial detail there is we came around at about, I think, 6 p.m. and left at about 3 a.m.
That's right.
Really fun evening. All right. So now, as always, for early career listeners, could you talk a little bit about how you got into international law and the career path that has brought you to your current job at the ANU? And we might speak in kind of our wrap-up question about current projects, about what specifically has taken you to Geneva. But for the moment, what was your path into international law and onto the ANU?
So it's appropriate that we've already mentioned Jessup, because it was the Jessup Moot competition that I did in my undergrad that really got me into international law. I did my undergraduate degree at UWA. I'm originally from Perth, and in 2002, I was selected for the UWA Jessup team. I had fantastic teammates who I'm still friends with and who are now doing amazing things all over the world, and wonderful coaches, including Julie Taylor, who's a barrister in Perth, and James Edelman, who is now a judge on the High Court of Australia. We were fortunate enough to do really well. We ended up winning the World Rounds in Washington, DC in 2003. And as part of my pleadings, I was always second respondent. I just had one set of issues to plead. And one of them was I had to rely on a general principle of law. And as we went through the Australia rounds and the international rounds, I just got more and more frustrated with having to make this argument, because judges would keep asking me, well, what is a general principle of law? How do you find it? What's the criteria? And I could never come up with an answer that I found satisfactory. So I ended up doing my honours thesis on the topic to try and answer this question. And James Edelman was kind enough to supervise me. We had a meeting early on, and he said to me, paraphrasing, Imogen, I'm really happy to be your supervisor, but there's one problem. This isn't a 10,000 word topic. This isn't an honours thesis. This is really a PhD thesis. And I said, yeah, whatever. What do you know, future High Court Justice James Edelman? I can do this topic in 10,000 words. Turns out, unsurprisingly, Justice Edelman was right and I was wrong. And at the end of those 10,000 words, I completed the honours paper, but I'd barely scratched the surface of what I wanted to say. So I went on to graduate. I sort of got a bit away from international law. I thought it was important that I practiced, and I worked for a civil litigation firm in Perth. But the question of what is a general principle of law never left, and it was always humming in the back of my head. So after a couple of years, I left practice and I came to the ANU and I started a PhD on the same topic. During the PhD, I did as much casual sessional teaching as I could in any course I could, not necessarily international law related. And at the end of that process, I was fortunate enough to be able to secure a full-time academic position at the ANU, based both on my research, but also on the teaching experience I'd accrued along the way. And I've been there ever since, with gaps along the way when my children were born, and the PhD eventually turned into the book that you so kindly referenced at the top of this podcast. One thing, though, I do want to say about my career path is I never studied overseas. I think there's sometimes a bit of perception about international law careers, especially if you're coming from Australia or New Zealand or one of the smaller countries, is that you need to go and do a LLM at Oxford or Cambridge or Harvard or the like, or you need a PhD from an institution from a different country that your undergraduate degree is from. I never did those things. My degrees are from the University of Western Australia and from the Australian National University, and that's it. And I do think studying internationally is wonderful, but I also think it's important that we recognise it's not possible for everyone. Whether people have financial restrictions, whether they have family or other caring responsibilities, it just might not be feasible depending on people's personal circumstances. But if that's the case, it doesn't mean you're precluded from pursuing a career in international law academia. I think sometimes in Australia in particular, we have a bit of a cultural cringe about our own universities, but we have great international lawyers and we have great international law schools in the country. And I think we can be really proud of that.
I'd agree with all of that. And that very much echoes something that Juliet said in episode 1 about, you may have a vision of what you think the perfect next step in your career is, but there'll always be something that is kind of adjacent to it or the next best alternative. And careers are made up of these often unexpected decisions that we take, and there's no one right way to do it. And while I did study overseas myself, obviously, to a great extent, that started with a desire to travel, right? And I was lucky that I could find a package of funding that would allow me to do it, without which I don't think I would have been able to do it. But the motivation wasn't entirely a pure-hearted view that I was going to learn more about international law somewhere else. Anyway, thank you for that. But let's move on to our main topic this evening. So for once, we're moving beyond questions of conflict, security, and international criminal justice to look at the equally uplifting subject of the climate crisis. Now, yes, jazz hands for podcasts being a visual medium. Now, in a full and busy docket at the International Court of Justice, there are also proceedings requesting an advisory opinion from the ICJ on the legal obligations of states in respect of climate change. But before we get down into the legal weeds, Imogen, could you tell us first how this came about? And second, for those who aren't familiar with these distinctions, what an advisory opinion is and how it differs from a case between states at the ICJ?
Absolutely. And in true Jessup form, I'm going to start with your second question first. So what is an advisory opinion? The ICJ is empowered to hear two types of cases. Contentious cases are those brought by states against another state. Now, there are various ways that states can consent to the jurisdiction of the court, which is far beyond this episode, at least, perhaps a future one. But if they have consented to the court, then every ICJ member, which is every UN member, because UN members are automatically members of the International Court of Justice, can bring a claim before the ICJ against another state if that other state has also accepted ICJ jurisdiction. And contentious cases are binding on the states that are party to them. So they resolve a dispute directly between states and they make a legal order about whether a state has breached international law and what are the consequences that flow from that. The other type of case that the ICJ is empowered to hear are advisory opinions. And as the name suggests, it's the advisory capacity of the court. So it's essentially a legal opinion about a state of affairs, but it's not binding on any state or any entity. Only certain UN bodies are authorised to request advisory opinions. And these are organs, including the UN General Assembly, UN Security Council, and then other specialised agencies, including, for example, the World Health Organization, UNESCO, and others. In practice, the vast majority of advisory opinion requests have come from the UN General Assembly. And that's exactly what happened in this case. So the way that this case got to the ICJ is on 29th of March last year, so 2023, the UN General Assembly transmitted a request to the ICJ for an advisory opinion on the obligations of states in respect of climate change. The resolution was introduced by Vanuatu and it was adopted by consensus, which means that all 193 members of the UN General Assembly agreed to it.
There's only a limited number of General Assembly resolutions that we see that have that consensus, and that says something about, I suppose, the moral weight of the case and also the cleverness and statecraft of Vanuatu's lobbying. Okay,
Absolutely.
but we're still waiting for the filing of written submissions, right? So an actual hearing is some way off.
That's right. So there's been a number of sort of extensions in the timeline. With an advisory opinion, all states are entitled to submit written statements. And because this is of such interest, a very, very large number of states want to do so. Now, quite a few have already, but there are some that haven't. And once statements are submitted, then other states have an opportunity to comment on the statements that are submitted. So the court has been sort of just pushing back, giving states time to submit these things. And most recently, the time limit's been extended to 14th of August, so next month, which means that we're still quite a while off actually having any oral submissions or having the court actually give its opinion.
Right, and that does, and I mean, we'll come to this later, that the ICJ is not the only forum where climate change cases are going on. So there is part of the issue for the ICJ is going to become the later its case runs, the more jurisprudence it's going to have to take into account from other courts and tribunals. But so I guess my sort of first question for you off the back of all that is, so we've talked about how the case formally came up from the UN General Assembly and was officially sponsored by Vanuatu, but there's a bit more to the story, isn't there?
There absolutely is. So, and this is a story I love. I feel it's one of the real feel-good stories in international law at the moment. Although Vanuatu spearheaded the initiative in the UN General Assembly, and I'm not taking anything away from Vanuatu's advocacy in this space, I think they did an exceptional job. The process didn't actually start with Vanuatu as a state. Instead, it started with a group of students, of law students, from the University of South Pacific in 2019. And I'm going to actually quote a bit from an article with Cynthia Hunihi, who is the president of the youth advocacy group Pacific Islands Students Fighting Climate Change. And I want to do it because it's their story, not mine. And this quote's from an article published on nature.com, which I highly recommend, and I think we might put a link to in the podcast comments if we're able to.
Absolutely.
So this is Cynthia's words. Our journey began in a classroom in Vanuatu at the University of the South Pacific School of Law and Social Science. 27 law students from 8 Pacific Island countries banded together when our professor challenged us to research the most progressive legal pathways to address climate change and to propose one at the 2019 Pacific Island Leaders Forum meeting in Tuvalu. We chose to agitate for an ICJ ruling because of the most ambitious action on our list. And in the face of an existential threat to our people, ambition is what we need.
Wow.
So this was, it's really powerful, isn't it? And the whole article is. But this was a classroom exercise. You know, this is the type of thing that you or I might challenge our incredibly intelligent, incredibly motivated students.
Right.
And be inspired by what they come up with. But it's rare, I think, that those things move outside that classroom setting.
Yeah.
And in this case, the students were able to do that. They were incredibly effective in their advocacy. They first targeted the Pacific Island Forum because they knew that they had to get the Pacific leaders on board. And they managed to get formal endorsement in 2022 from the Pacific Island Forum. And then following that, they moved their campaign to New York and they targeted the General Assembly, knowing that they had to convince a UN body to request the advisory opinion. Vanuatu, as I said, took up the mantle because it had to be a state in the General Assembly, but the students were involved the whole way through. And a core group of the students were lead negotiators on the draft text of the resolution that was finally adopted.
Wow. That is an astonishing story. I mean, you and I both have our experiences of the Jessup Moot, which is fantastic, but is ultimately a mock international law exercise. And here are these students assisting in the drafting of an actual General Assembly resolution.
I know, it's sensational, isn't it? I just think it's tremendous on so many levels. I mean, it's vital. It's a vitally important topic. The fact that it was adopted by consensus, it was the first advisory opinion request to be adopted by consensus. So to have that level of support that they gained, but also I think it's such an important story about the power of advocacy.
Right.
And the power of people who aren't international legal subjects necessarily in their own right individually, who don't have a direct voice to the UN. They're not formally empowered. They're not state representatives. They're not foreign affairs ministers or heads of states. They're students. But by banding together and for fighting for something that they really believed in and doing so, with incredible intelligence and knowledge and use of the law, have been able to achieve something absolutely wonderful.
Yeah. And look, I don't want to take away from anything you've just said because I'm in furious agreement with all of it, but it does also overlap with one of my interests, which is, the role of the agency of small states in the international realm, because they're often seen as objects, that the only states with any real power are the great powers and maybe to some extent middle powers. But one of the things about being in a smaller jurisdiction like that is the number of steps or barriers between those students and real decision makers is much fewer. And then my experience of small jurisdictions is, if a couple of key people at the top decide this is a national priority, it is, everything swings into gear. Resources might be limited, but the agility of small states compared to the large, well-resourced bureaucracies of, say, an Australia or United States or, a European country is often able to achieve things where larger states just wouldn't think that this could be done by a smaller state. And it's about that clarity of purpose and the ability to line things up. And of course, also on these issues, obviously, small island developing states speak with great moral authority because they're on the front lines of climate change, which to some extent sort of brings me to my next question for you, which is that, in your academic work, you've written about the concept of intergenerational equity and this advisory opinion request. Can you explain the relevance of that concept to what's happening here jurisprudentially?
Yes. So I'm just going to, when we look at the requests that the General Assembly sent to the ICJ, in part, what they asked was the ICJ to answer, and I'll just read from the request, what are the legal consequences under these obligations for states, these are states causing climate change or contributing to climate change, where they, by their acts and emissions, have caused significant harm to the climate system and other parts of the environment with respect to, now, firstly, small island states, but secondly, and this is the point for this part of the discussion, peoples and individuals of the present and future generations affected by the adverse effects of climate change. So not just people currently alive, but people who are yet to be alive, future generations.
Right. So that issue is front and center in the request itself.
That's right. So it's been really brought out. And so this concept of duties owed to future generations of people is not a new one. It's one that is sometimes called intergenerational equity. So it's often has come up in the context of equitable sharing of resources. So that when we're looking at equitable sharing of, let's say, water, clean water, the equitable sharing should not be done just with mind to current people who depend on that water, but also future generations who will also need to depend on that water resource.
Can I ask what the status of that idea is in law? So is it a kind of a guiding policy principle, or is it to look to your specialism, a general principle, or is it seen as a sort of subcomponent of another rule? Like, how do lawyers use it?
Use it. So, I mean, and that's actually exactly where, my argument is it should be a general principle, and it could be considered a general principle and could be binding at international law. In terms of how it's been used so far, it's really been partly, a guiding principle, particularly in the environmental law space. And then domestically, it's been applied.
Right.
So we've seen it applied by domestic courts, particularly in, as I said, in the cases of water resources, is where it's come out. But internationally, it's certainly not been recognised as a norm of customary international law.
Right. So the ICJ case could be revolutionary, right?
Absolutely.
If they look around the sort of legal systems of the world and say, well, we can see it being used here and here and here, whether we call that a general principle of law recognized by the various legal systems of the world, or whether we call it evidence of custom, then maybe the principle will have some more traction. I think we've seen a similar trajectory, though maybe it hasn't fully crystallized yet, with the idea of environmental impact assessments being compulsory and mandated by international law in certain contexts.
Yeah. But the difference here, and this is why I think actually a general principle is the right route to go, as opposed to a customary norm, is when we look at where this principle manifests, it manifests in traditional state-based domestic legal systems, yes, but it also manifests in non-traditional legal systems. And in particular here, I'm talking about things like customary legal systems, which many of the Pacific states have. I'm talking about Indigenous legal systems, and I'm talking about religious legal systems. Now, things from those legal systems, it's difficult to argue that they are state practice, but I think it's easier to argue, and it's an argument that I'm fully supportive of, that when you assess legal systems of the world for general principles, you are not limited to state-based legal systems,
right?
But you can cast a net more widely to look at religious, customary, Indigenous, non-codified legal systems.
Fascinating. So just to back up a moment for any general listeners or student listeners, so obviously the International Court of Justice is a court of law, and it has a limited range of sources of law it can look to. Obviously, it can look to treaties binding on the parties. So that's the first thing anyone who knows anything about international law thinks of. In a number of these podcasts, obviously, we've discussed the idea of customary international law, so the unwritten rules of international law that are generally proven by the things states uniformly do, but that where states also say we're doing this because it's legally required. But then the neglected child of the sources of law family is your favorite general principles, which is this idea of general principles of law. I mean, in the horribly old-fashioned language of the statute, as I recall, is general principles of law recognized by civilized nations. Now we tend to kind of reinterpret that as meaning kind of, principles of law you would find representatively distributed through the legal systems of the world. And I've always thought that's been as a non-specialist, I've always thought that was a really underutilized source of law, particularly in fields like international criminal law, where people will say things like, oh, well, the defense of duress is customary international law. And I'm like, no, it's not. There's absolutely no way you're going to deduce from the practice of states that they all believe that in an international criminal trial, this defense is available. It's just a general principle of law. You look around and states, and you see it in most legal systems.
So it's funny you say that, because one of my favorite uses, I have several, because as you say, I have a soft spot for this source of law, but one of my favorite uses of general principles is actually by the International Criminal Tribunal for the former Yugoslavia in the Forensica case. And they look at definitions of rape, and they actually do a comparative study of definitions of rape in various domestic criminal systems and extract that to the international level. But just to respond to that in two ways, because the word civilized, as you say, it's a bit embarrassing, isn't it, to have that there? And so we sort of pretend it's not.
I think my child would refer to it as cringe.
Cringe, exactly. The problem with pretending it's not there is we sort of ignore the fact that it did actually guide the way this source has been used. And Dina Zavala, who I know is part of this podcast team, and I actually have a book chapter coming out on this in terms of how the inclusion of the civilized modifier wasn't a mistake and it wasn't unimpactful. And it has actually guided the way general principles have been used. I mean, Judge Imogen famously called them a concert of Europe in the North Sea continental shelf case. And when you look at when judges have used them, they usually look at a civil law country and a common law country, usually either side of the English Channel. And then they might throw in the US and maybe Germany, good measure. And so it's been very much a Eurocentric use of the provision for definitely the entirety of the work of the Permanent Court of International Justice. And sad to say, the majority of the work of the International Court of Justice. But there are a few sort of shining lights along the way. Judge Imogen was one in North Sea continental shelf. He looked at Islamic legal systems. Judge Al-Kashari in the aerial incident Lockerbie did the same. And then, perhaps most famously, Judge Weeramantry, in his separate opinion in the Gavchikovo-Nagamaras case, extended it to look not just at Islamic systems, but Hindu systems, and then what he called living systems of law. And by this, he meant Indigenous systems. And he argued, I think, very persuasively that if we're talking about a source that is meant to encompass, the systems of the world, then we artificially restrict it to just look at state-based legal systems. And instead, we should cast that net more widely. And I think that was true in 1997, and I think it's even more true in 2024.
Right. And I do think that's one of the things that as lawyers, particularly academic lawyers, we have to grapple with is, what counts as law and how wide should we cast that net? And why are not Indigenous systems of law, traditional systems of law, as worthy of as being repositories of legal principles as anything else? But the reference to the Global South sort of brings us to my next question, but en route, I'm just going to observe that we've both settled on the same pronunciation, be it wrong or right, of Gabchikovo-Nagamaros, as Tamsin and I debated in episode 2. But anyway, so this case, how it's come about, what it implicates, where the rules may come from, plainly implicates the Global South, and as we've discussed, small island developing states. Do you think this is part of a trend as to how the ICJ is being currently used?
Yeah, I mean, I do. I guess a few things to say about small island developing states is, we both mentioned that they're disproportionately affected by climate change. But I just wanted to talk about that a little bit because, I think most people are very familiar with the idea of rising sea levels causing land inundation, causing islands to sink. And there's been some very famous press conferences of prime ministers standing, in the waves to gain attention. But it's not just increased sea levels that are a problem for small island states as a result of climate change. You have increased intensity of weather events, to which small island states are particularly vulnerable. And then you also have increased salinity in the water, because when water temperature rises, the concentration of salt is able to rise. More salt can be dissolved in hotter water. Water gets hotter and saltier. And what this means is a lot of small island states, in at least part, depend on these things called freshwater aquifers for their drinking water. The Marshall Islands is one of them. And these are essentially freshwater lenses. So it's just a layer of freshwater that floats above saltier water. And as long as those layers aren't disturbed, the freshwater can be used as groundwater, as drinking water for the people. But as the combination of hotter, saltier water and rougher weather means that these freshwater aquifers are actually in danger themselves. So even if your island might not sink, the conditions of life on it are going to get very, very difficult. And so small island states are vulnerable in all manner of ways from climate change. And in international law, as we both know, we have this concept of the specially affected state, that we, at various points along the way, we take into account to a greater weight those states who are more specially affected by a breach of international law. We do so when we look at formation of custom. We do so when we look at who has standing to plead a case. And it's right that we do so, I think, when you look at consequences of breach, who is more specially affected by that breach. And so the the General Assembly phrasing this request in terms of particularly looking at the impact on small island states, I think is very appropriate in this case. But it is, as you suggested, I think fair to say that there is a significant use of the ICJ and perhaps other dispute procedures at the moment by global South countries. If we look at South Africa's case against Israel, which I know you've been talking about on the blog, Nicaragua's case against Germany, which isn't to say that global South hasn't used the court in the past, of course, but I feel that there is perhaps more of a strategic move to really start litigating these interests in a very visible way by certain countries. Now, Doug, and you might have something to say about that, of course, too, because your work on small island strategic litigation. But the other thing I'm mindful of is, although you are a criminal court expert and have been speaking a lot on that on the podcast, you are also very much a law of the sea guy. And while the ICJ has this advisory opinion before it, there has been, as you've mentioned, an advisory opinion already handed down, which was the one handed down by the International Tribunal for the Law of the Sea. So I was wondering, perhaps it might be nice if you could talk a bit about how that case came about and what you think the impact or the significance of it might be for the ICJ proceedings.
Right, yeah. So, I mean, a number of things together there, the role of the Law of the Sea Tribunal, the role of small states, and how this might feed into the upcoming ICJ proceedings. So let's perhaps just start for listeners with a quick primer on the International Tribunal for the Law of the Sea, or ITLOS, because it's not necessarily as well known. It is certainly not known as the World Oceans Court, as some Americans seem incomprehensibly addicted to calling it. It's got a name. We don't need to give it. We don't need to give it another name, right? I think
the World Oceans Court.
Well, because Americans refer to the ICJ as the World Court, right? And so I think, therefore, the ITLOS has to be the World Oceans Court. Anyway, it's established under the UN Convention on the Law of the Sea, or UNCLOS, one of the world's most important multilateral treaties. And it's important not just because it's widely regarded as the international constitution for the oceans. It's important because it binds 169 member states, which gives it a reach basically unparalleled by anything other than the WTO agreements or the UN Charter. So it deals with a range of issues, including marine pollution and protection of the marine environment. So ITLOS, the International Tribunal for the Law of the Sea, is the permanent tribunal established under UNCLOS, and it's based in Hamburg, and it hears UNCLOS-related disputes and, under certain conditions, requests for advisory opinions. It has 21 judges, which is more than the 15 of the ICJ, because at the time the convention was negotiated across the 1970s and ending in 1982, the states of the Global South wanted a more widely representative tribunal when it was established. They weren't confident in the representativeness of the ICJ. Now, all of that said, while that sounds like a lot of judges and a really big tribunal, only the president of ITLOS is permanently resident in Hamburg. The other judges basically fly in to hear cases when essentially the ITLOS bat signal goes up. So many of them have day jobs in academia, and the tribunal pays them an annual stipend, and then they're paid only for the days of work they're present in Hamburg on tribunal business. All right, so how does this tribunal hear an advisory opinion? Because most of the cases that come to it because there is a dispute between two states concerning the application or interpretation of UNCLOS itself. Well, the tribunal has held in the past that Article 21 of its statute, which is part of the UN Convention on the Law of the Sea, authorizes it to give advisory opinions where another treaty authorizes an international body to seek an advisory opinion from ITLOS. So it doesn't have an inherent advisory jurisdiction, but it has this power to hear matters referred to it under a treaty. So taking up that invitation, essentially, Antigua and Barbuda and Tuvalu, two of the small island states profoundly threatened by climate change, established by treaty the Commission of Small Island States on Climate Change and International Law, commonly referred to as COSIS. So one of the perhaps relatively few powers conferred on COSIS by its establishing treaty was a power to seek advisory opinions on climate change from ITLOS. And this was just done by two small states. But COSIS now has 9 member states. So the COSIS Treaty was signed on the eve of COP26, the UN climate change meeting, and it was basically born of a frustration that business as usual politics was not going to avert catastrophic climate change. So to oversimplify, the Paris Agreement on climate change relies on a system of nationally determined contributions. That is, states volunteer to cut their greenhouse gas, their GHG emissions. And you just have to hope that whatever they find politically feasible to do individually will add up collectively to enough. So the member states of COSIS, and this sort of goes to your point about how you use international litigation to change politics, wanted to reframe climate negotiations, not in terms of what is politically feasible, but in terms of what is legally required. So the ITLOS advisory opinion request was submitted in December 2022. And the key questions, boiling it down, were first, what is required under the UNCLOS duty to prevent and reduce and control pollution of the marine environment? And second, what is the content of the duty to protect and preserve the marine environment under UNCLOS in the context of climate change? So the case was argued in September 2023, or it wasn't argued as a case, there were submissions because it's an advisory opinion, and that advisory opinion was handed down in May 2024. Now, one thing to note here is that is fast by international standards, right? You know, that's a year and change, and it's especially fast when the final opinion weighs in at 153 pages. The core of the decision, though, fatal last words from a lawyer, is relatively straightforward. ITLOS held that anthropogenic greenhouse gases constitute pollution under UNCLOS. Now, that might just sound like a fairly abstract thing, but once something is classed as pollution, and pollution that affects the ocean, then a whole lot of other duties are triggered under the convention. Now, the tribunal's full decision looks at a range of international agreements and a range of provisions of the convention. For our purposes, I just really want to focus on one, which is Article 194. And the tribunal held, applying Article 194 here, and I'm quoting the tribunal, and I'll come back to quoting the article, state parties to the convention have the specific obligations to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic GHG emissions and to endeavour to harmonise their policies in this connection. Such measures should be determined objectively, taking into account inter alia the best available science and relevant international rules and standards. Now, that might sound a bit anodyne, but what followed from this was that the tribunal rejected submissions that all that was necessary to meet your UNCLOS obligations in respect of climate change was to fulfill obligations under the United Nations Framework Convention on Climate Change and the Paris Agreement. The tribunal was crystal clear that what had to be done was what was objectively necessary as determined by the best available science. So in implementing that, the key duty is to act with due diligence and, again, to quote the tribunal, given the high risks of serious and irreversible harm to the marine environment from such emissions. Then they massage this a bit. However, the implementation of the obligation of due diligence may vary according to states' capabilities and available resources. So there's a bit of room given there. While they say that there's a strict duty of due diligence, they acknowledge that states' capacity to implement it might vary. A number of other UNCLOS duties are then activated by those findings, including the obligation to conduct environmental impact assessments, to engage in international cooperation in developing effective measures, to engage in technology transfer to developing states, and to conduct scientific monitoring of the effects of climate change and transparently share that data. There is a lot in there. But the core finding, the legal obligation to do what is necessary in light of the best available scientific evidence, puts a lot of legitimacy behind small island state claims that more needs to be done in climate negotiations, because they can now claim correctly that what the law requires is to do what is objectively necessary and not just what is politically palatable.
Fascinating. Oh, I was going to say that's fascinating, and you think, and you're probably going to go on to this, and I'm foreshadowing you, but the ICJ will have read it very carefully. I'm sure the judges will have, and it's going to be something that's going to be taken into account when the advisory opinion does get handed down by the International Court of Justice.
Yeah. Well, and so ITLOS, having got its climate change advisory out opinion before the ICJ, gives it this first mover advantage, right? So it's essentially going to be impossible for parties arguing before the ICJ now, and the ICJ itself, not to take it into account. That said, the ICJ is a court of general jurisdiction and will be able to rule on a much wider range of treaties and rights, including human rights treaties. And there was some criticism that ITLOS didn't take enough into account questions of human rights. There is just one sort of interesting wrinkle, though, I'd like to draw to everyone's attention, Imogen, and see if you see in it what I see in it, which is, I said the critical article of UNCLOS for present discussions was Article 194. Let me just read you kind of part of it. So Article 194.1 says, states shall take individually or jointly as appropriate all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source, using for this purpose the best practical means at their disposal and in accordance with their capabilities, and they shall endeavour to harmonise their policies in this connection. So that to me sounds like a classic duty of due diligence, right? There's not an absolute there. I mean, we've said it's been informed by this requirement to do what is necessary, but it's sort of a procedural direction. Here's the interesting thing about Article 194, paragraph 2. States shall take all measures necessary to ensure that activities under their jurisdiction or control are so conducted as not to cause damage by pollution to other states and their environment, and that pollution arising from incidents or activities under their jurisdiction or control does not spread beyond the areas where they exercise sovereign rights in accordance with this convention. So that's normally called the sort of transboundary pollution principle. And that appears to be an absolute obligation to prevent transboundary harm in cases of pollution. But what if they defined as pollution? Greenhouse gases. So on its... So Imogen, what do you make of that?
Well, I'd say that there's no way to prevent greenhouse gases from transmitting outside your territory. It's not it's not a more traditional form of pollution. So I'd take from that once that that's essentially a prohibition on producing them in the first place.
Right, that's exactly it. Like from first principle, it's hard not to read finding that greenhouse gases are pollution and the absolute prohibition on transboundary harm in Article 194.2 as actually to some extent saying if you cannot keep greenhouse gases inside your own jurisdiction,
within your territory,
you've just got to stop producing them. So that is a potentially fairly wide-ranging finding that a number of people have seen in the decision, and we're just going to have to see how that plays out.
Can I just add to that? Linking back to the advisory opinion, So one thing I want to say, and again, perhaps for those who aren't, as familiar with the intricacies of the statute of the International Court of Justice as you and I are, the ITLOS advisory opinion is in no way binding on the International Court of Justice.
Right.
There's no sort of precedential system in international law.
Right.
But when the ICJ considers what it takes into account, Article 38(1)(d) of its statute says that it takes into account essentially court decisions of the highest courts. And that includes not just national courts, but it includes other international courts as well. And so the International Court of Justice, by using this provision, will have reference to the ITLOS advisory opinion, and can do so as what we call a subsidiary source of law. It doesn't bind the ICJ, but it will be highly, highly influential. In terms of, the wider mandate, I think it's interesting just to comment that the advisory opinion does specify that the UN Convention on the Law of the Sea is one of the things the ICJ will take into account, but it does add to it the human rights conventions as well. So in particular, the International Covenant on Civil and Political Rights, International Covenant on Economic and Social Rights. So you're absolutely right. We'll see a wider gamut of sources of law that will inform the ICJ advisory opinion.
And I've only just thought of this. I mean, other than judicial restraint in not wanting to go too far beyond the legitimate bounds of the UN Convention on the Law of the Sea, ITLOS may have taken some comfort in not addressing those questions in the knowledge that they were before the ICJ, and that perhaps kind of sticking to their core mandate was sort of in their best interests in terms of developing the law in a systemic and coherent way.
And minimising backlash against their decision.
Well, we can talk about how Law of the Sea lawyers fight about Law of the Sea on another occasion. But anyway, so look, I think we're probably at the wrap-up segment. So at the end of these conversations, I normally ask 3 questions of my co-host, and those are, what recommendations do you have for anyone who'd like to know more about what we've discussed today? And we've already had some along the way. And what are you working on at the moment, which might tell us a bit about why you're in Geneva? And what's your current escape route? What are you doing or reading or viewing that takes your mind off international law?
Great questions, Doug. So my first answer is, what should you read? I think the most important thing to read is actually just keep an eye out on the advisory opinion itself. So the ICJ has a great website that publishes all of the orders. It will publish the written statements as they are made public, and it will finally publish the order of the court. And so I think for anyone interested in this, that would be a great thing to follow, and to read the written statements as they are made available would be something very interesting to see. The article from Cynthia Hunahu, as I said, in nature.com, I really recommend for a background of the case. If you're interested in advisory opinions more generally, there's a great special issue from 2021 of the Melbourne Journal of International Law. It has articles from people such as Justice Hilary Charlesworth, our esteemed podcast host, Doug Guilfoyle, and really goes through a number of different aspects of advisory opinions. So I think that's fantastic. And if you do want to learn more about this weird little source of law in Article 38(1)(c) of the statute, I will plug my own book. It's excellent. Many, many pages devoted to this one source.
Terrific. And what's got you in Geneva at the moment?
Yes, so I'm part of a research team along with 2 other researchers from the ANU. We're on an Australian Research Council funded 5-year project, which is called Reconceiving Engagement with International Law and Institutions in a Populist Era. Now, we have the 3 of us from ANU, and then we have 2 partner investigators in the US. And we've actually been working on this project in various guises since 2019, but we've started the most recent iteration of it in 2022. And really, it was prompted by an observation that many, many people have made, not just us, but the sort of creators of, and in some ways most staunch defenders of the international legal order in 2016, 2017 seemed to be turning away from it. You had the UK rejecting at least European integration with Brexit. You had a lot of rhetoric against international courts coming out of Britain at the time. You had the US withdrawing from the Paris Agreement, defunding the World Health Organization, destroying the appellate body in the World Trade Organization. And so we started asking this question, what's happening? Why are these countries that have benefited so much from the international legal order, why are they now perhaps not seeing the benefit in it that they once did? And as we refined the project, we started looking at populism as perhaps a driver of this behaviour. And we designed a project to look at 4 country case studies. So as well as the US and the UK, we've extended it to look at India under Prime Minister Modi, and the Philippines under President Duterte. And then we're really interested in looking at the engagement of these states in 4 international institutions. So the UN Security Council, the UN Human Rights Council, the World Trade Organization, and the World Health Organization, the 4 key organizations that look after peace and security, trade, health, and human rights. 3 of those institutions are in Geneva. So that's essentially what we're doing here. So I'm here with Professor Jeremy Farrell and Professor Jolyon Ford, both from ANU. And we're very lucky to have funding to be here for 2 weeks, trying to have as many interviews as we can with diplomats, with policymakers, and with academics who specialise in each of the fields. So we've been talking to people at the World Trade Organization, we've been talking to people involved in the World Health Organization, with the UN Human Rights Council. We've had an event at the Graduate Institute of Geneva yesterday, and we're just trying to get as many perspectives as we can about essentially what's been going on in these international institutions.
Terrific. No, it's a really interesting project and very timely for all the reasons you outline. I think there is a sort of general sense that the international order that people broadly of our generation grew up with in the 1990s is under strain and reconfiguring in ways that need examining.
Absolutely. That's one of our questions really is, and I think it's really interesting you go to that straight away, is how do you tell how much is actually just a destructive impulse or a rejection of an international institution that is actually a rejection of internationalism, and how much of it is more a reconfiguration or a reimagining of what these institutions could or should be? Because, you know, we are the post-World War II UN era. It's the longest we've ever had international institutions. You know, the League of Nations era was vanishingly short in comparison. And so there is, I think, some valid questions to be asked about, are the international institutions in their current form really what the world needs with the challenges we're facing? Or does there need to be some kind of reimagining or recreation?
Right.
We use a lot of rewords in the project: renew, recreate, reimagine, reconceive. But I think there is a feeling that things are shifting and no one perhaps knows where it's going yet, but it's important to examine what states are doing and how they're doing it.
Very interesting. Imogen, can I take you to escape routes? Yes.
So I love to read. One of the things I find, though, is that after having read a lot of academic work, and, you know, a lot of the topics we read about are not, as you say, overly optimistic, I need a book that is very much a escape from reality. And a rom-com is my pick of choice. But it has to be well written. I cannot abide something that is sloppily written. I've got exacting standards. I want it to be light and fluffy, but I also want it to be excellently written.
Sounds like you need the literary equivalent of the perfect souffle.
Exactly. That is the best way of describing it. I need a souffle of a book that I can sink into and will satisfy my sweet tooth, but won't make me throw it across the room in disgust at the writing. So the last series I've read that really fulfilled that is an Australian series by an Australian academic and author called Jodie McAllister. Now, Jodie's academic work is on the Bachelor franchise and on reality TV romantic comedies. Yes. So she's done all this incredible work looking at reality romantic scripted or not scripted TV. And then she's written a trilogy called the Marry Me Juliet series. And Marry Me Juliet is a fictional bachelorette type series. There's one Juliet and a number of Romeos who get locked in a house and vie for her affection. And at the end of it, one Romeo is chosen. I just loved it. My partner gave me 3 books for my birthday, which was last month. And I thought, I'll save them for airplane reading. and then I read them all in 4 days before I left. So that was not a great outcome in terms of my plane journey, but a great outcome in terms of my enjoyment beforehand. And what I really liked about them too is they're set in Australia, which is, I always find interesting. But the first one was actually set, and I'm not going to give too much away because I do recommend anyone who's a fan of rom-coms to go and check them out. But the first one was set at the very beginning of COVID. So you have the added complication is not only you filming this reality TV show, but suddenly everyone's locked down and no one can leave the set.
Right.
It's when stage 3 or 4 restrictions come in, and that's it. It's a closed set. And so how you deal with that on top of everything else that is going on with your contestants. I thought it was terrific.
That sounds like a great scenario.
Mm-hmm. And just perfect in terms of a refreshingly light dessert for the brain.
Right. Okay, fantastic. Well, Imogen, shall we wrap up there unless there's anything further you want to ask?
Well, I do indeed, Douglas. I have one question, and that is, would you share with me, I can see, but perhaps the listeners, what you are wearing today?
Right. Okay, we're back on the what is Douglas wearing question. So today I'm wearing I've hung it up for the purpose of the podcast, a new green twill wool jacket that I'm very happy with. And I've been wearing a sort of color aligned, not precisely matching green wool waistcoat, but I'm particularly pleased with some high-waisted green corduroy trousers I got my local tailors to make that I'm wearing with braces, which, as I've said on a previous podcast, is sublimely comfortable. I'm discovering that in middle age, one of the joys of life is actually having trousers that fit. And if you need to get someone to make them for you, then that's just a path you should go down if you can afford it. And I've also got a new green and blue paisley tie I'm feeling quite good about. So, yep, for the curious, that's what I'm wearing.
And very lovely it looks too.
Well, that's very kind. Well, Imogen, thank you for starting your day in Geneva with the pod. I will leave you to get on to interview the good burgers of the WTO and the UN system. And for everyone listening, bye-bye. We will see you in a week.
Goodbye, and thank you, Douglas.